Right off the bat, the judge makes it clear she can only consider stipulated facts. That means only the evidence both sides agree on is fair game, not just allegations or speculation. Already, this sets the tone. No shortcuts, no guesswork.
And, we had another discussion yesterday where Mr. Schmidt is contemplating amending count 1 from attempted homicide to first degree recklessly causing injury. And I think I responded to that with an observation about enhanced penalty from the original charge of second degree recklessly causing injury with a firearm. Answer: the court, Mr. Schmidt and I agree, the court made a mistake in its decision. The penalty for second degree recklessly causing injury with a firearm enhancer, the enhancer adds 5 years to that. So,
Actually, possible penalty of 12 and a half.
12 and a half.
That's what I said. I knew that.
Oh, well, okay.
I was well aware.
That isn't what we, in any event.
It enhanced it from 12 and a half to 17. That was.
Yeah.
Oh, okay. So from 12 and a half to 17 and a half.
I think the maximum penalty for that felony is 7.5, 5 years ES. The enhancer adds 5 years confinement portion, so it would be 7.5, 12.5,
modifier?
5 ES. Firearm modifier.
It does not. If the statute specifically says it does not increase it by any additional time if the underlying facts related to a firearm.
No. It says, so first of all, second degree reckless endangering safety is a Class F felony. Class F felony is the imprisonment. You're right. It's 12 and a half years total.
See, I did it correctly.
Balance scale. Notice what's happening here. The defense is basically bargaining down. Instead of attempted homicide, they're pushing for lesser charges like firearm possession and reckless injury. Classic strategy. Admit to what you can't beat and fight the rest.
That up. So it increases it to 12 and a half.
Exactly.
And the court is saying, though, about the essential element thing. Possession of a firearm, possession of a dangerous weapon, or use of a dangerous weapon, not necessarily element of recklessly causing injury.
No, but the underlying facts. What's the statute now? I don't have the modifiers.
I don't have it in front of me, either, Judge. Anyhow, you asked for the status. That's essentially where we're at. Mr. Schmidt and I are discussing. I met with Michael for just a couple minutes before this hearing. I've given him copies of the emails that Mr. Schmidt and I have exchanged. We're going to chat again. He's the one that ultimately makes the decision about this. My concern is I don't know what your thought is with respect to potential penalty in the public's interest. I'm lost on it.
I don't have a thought. My thought is, because I can't, as Mr. Schmidt said, we can't look at a case and we can't go, okay, well, we're looking at this many years initial confinement, and so we're going to charge based upon that. My thing is my job is to review any offer to see if it is in the public interest. And it doesn't mean a set amount of initial confinement years. It's just what was offered, the second degree reckless with the modifier, as well as 1 count of possession of a felon with a firearm and 1 operating a firearm while intoxicated. When we have 9 counts, 8 of them are serious felonies. The plea agreement as proposed didn't meet the public interest.
Judge, your relying, as I recall, in rendering your decision, relying on the allegations of the complaint, which I must emphasize are allegations. And
I'm going to interrupt you. I relied upon the stipulated facts by the defendant. That's what the court relied on.
Faced with open mouth, did you catch that legal math? Firearm enhancers add serious time. We're talking years stacked on top of sentence. This tiny detail could be the difference between 12 years or 17 years behind bars. Imagine how one statute line can change someone's life.
Because I cannot rely on anything else. The arguments from the state, as well as the stipulated facts from the defense, and believe me, I use word for word what was taken down by my court reporter. That's what I used. I didn't use any other facts alleged that were not stipulated by the defense.
did not stipulate anything with respect to the charges that were going to be dismissed, because there is, Mr. Schmidt and I disagree about how a jury will see this evidence. There are facts to support the defense to the felony in possession of the firearms, where those firearms were found downstairs in the basement behind the closet.
Counts 2 through 8, or at least 3 through 8?
3 through 8, not 2. The whole plan is that Michael's going to plead guilty to the facts, to the crimes that the facts support. Certainly count 1 as amended to second-degree reckless with the firearm enhancer. Count 2, possession of the shotgun as a felon. Now we propose count 9, which is misdemeanor possession of a firearm while intoxicated. And Mr. Schmidt and I have talked about
That was already included.
I don't think
9.
count 9
was.
was.
9 months it was.
Yes.
I guess my take on what's happened since then is that was Mr. Harrington's proposal. I had proposed instead to him leading to amended second-degree reckless endangering safety of the dangerous weapon modifier, and then all of the felon in possession of firearm counts, Ms. Marita and the intoxicated handling the firearm. And then we run the count 2 and 1 concurrent to each other, and counts 3 through 8 concurrent to each other. 3 through 8 are all the constructive possession ones. They're all in one location. They weren't using the function of time. Count 2 was, which is why count 1. In the meantime,
Fire. This is huge. The judge flat out rejects the idea of counting years as the only measure. Her job isn't just balancing prison time. It's making sure justice serves the public interest. But here's the twist. What the public wants and what the lawyers want often clash.
the reason why there's additional discovery is I started checking with law enforcement. My take on what the court's written order was, he was concerned about all the felon in possession of firearm charges. So I started collecting evidence about what is our evidence for that. I discovered that law enforcement did not actually send to us DA's office some of the evidence for that. That's part of the 4 gigabytes there. In particular, photographs of what the weapons, how they were arranged when the police found them versus how they staged them later and they were taking photos for documentation purposes. We also obtained photos of him handling the firearms in the past 5 years. We obtained those from the victim. That was actually just today. I don't know if Mr. Harrington has.
I haven't looked at that. I think Mr. Schmidt has advised in the email yesterday or early this morning that discovery was available, and I haven't looked at it yet. Handling the firearms in the last 5 years, I don't think that OWI conviction felony is 5 years old, is it?
I can look right up.
It was 2022. I believe the oldest photo is 2020. But I have not looked at the photos myself. I'm just reiterating the summary of the photos from the investigator who told me about this.
Mr. Harrington, to answer your question, the court has to look at what has been charged with the agreement that's been extended when I'm looking at the public interest. I don't know anything about your argument that none of those firearms were even able to be in Mr. Winquist's possession. I know nothing.
Camera with flash. And here comes the bombshell. New photos showing the defendant handling guns. This isn't just paperwork anymore. Pictures and evidence hit harder with juries than words on a page. You can argue law all day, but a single photo can destroy a defense.
I go off of what has been charged initially with the facts that I have stipulated to and with what was stated in the arguments. I did not have either one state at the arguments that counts 3 through 8 could not be proven beyond a reasonable doubt.
My position is there's a real question about that. There are defensible facts to counts 3 through 8. And my position always has been, Michael admits, count 2 certainly, count 1 as proposed to be amended, would admit count 9. Those.
Then it is what it is, and a jury can decide. You said that there are defenses. You can argue the defenses to the jury. The jury is the impartial body who looks at the evidence, who bases the testimony and determines credibility.
Because I know what the jury is.
Exactly. That's what it is. And if you are indicating that there are defenses to 3 through 8 possessions of firearms by a felon, when there have been no statements to the court that there were not firearms for count 3 through 8, then you argue it to the jury.
That's the status of our negotiations.
All right, so I can understand, Mr. Schmidt, you offered to amend count 1 to second-degree reckless, plead to counts 2 through 8, dismiss count 9, but have some concurrent and consecutives within.
Yes.
And Mr. Harrington made a counter offer of amending to second degree, again with the modifier.
No, I haven't agreed to second degree because Michael had. Michael
first
and I need to
degree.
talk about it.
Or reckless,
Yes.
just reckless.
Magnifying glass still to the left. Notice how carefully the judge draws the line. She'll only weigh stipulated facts, not raw allegations. Why? Because in criminal law, allegations mean nothing until proven. This is where courtroom drama gets real. Law versus perception.
My current proposal is amend it to second degree reckless with a firearm enhancer as was in the original offer.
And was it plead to 2 possessions of a firearm
2 possessions of a firearm plus count 9.
plus the misdemeanor? So we have 2 offers out there, and so it sounds like the parties are trying to work to find an agreement that may be acceptable in the public interest, or we go to trial.
And the one peculiarity with the defendant's offer is the second felon possession of firearm charge is the only gun I didn't charge because I can't connect it down.
Count 8,
No, it's not charged. It's
Oh,
a
it's
gun
not
that's not
charged.
referred in the complaint at all.
not even referred to in the complaint. So
That's
the
what
one
I'm
that
getting at.
cannot be connected to him, the one that was found allegedly in the kitchen that was perhaps owned by the victim, is not charged. See, now I'm having a better understanding of this case and the facts. As you stated, I have what is alleged in the criminal complaint, stipulated facts by defense, and the arguments that were presented to the court at the hearing. That's all I have available to determine whether or not the plea agreement is appropriate.
And I do think the agreement I propose is in our public interest, the one I've articulated prior to the additional.
All right, so that's where we are. We have final pretrial September 4th at 1 o'clock. Are we looking at having a status or something prior to that, or are we just sticking with September 4th?
I would prefer that we have a status before that.
Your August 14th date? August 14th at 10:30, I believe you're coming back.
Yes.
August 14th at 10:30, we will have another status.
So if you had, you can suggest a 9:45 might be available.
It is.
You do it 9:45? Because I already have 4 for 10:30.
Yes, you can do 9:45, or I can do 11:15.
9:45.
All right, 9:45.
I'm sorry, Jim. 9:45. I already have plugged in some things, so I'll be good.
Or I can move it to the 11 slot.
10:45 works.
All right. August 14th at 9:45. August 14th, 9:45, we'll have another status.
So, no resolution today. Instead, the case drags forward into another hearing. This is the grind of real courtroom battles, deals, counter deals, and constant delays. But here's the question for you. With evidence piling up, do you think the defense should keep bargaining or take their chances at trial?